The U.S. Supreme Court recently ruled in a landmark decision that the Second Amendment places a lot of restrictions on states' ability to deny concealed carry permits to other people. Basically what happened is the state of New York had a rule that in order to get a concealed carry permit, you had to demonstrate something called good cause. The Supreme Court, a majority of the justices there, ruled that under the Second Amendment it was not proper for the government to demand a showing of good cause before issuing a concealed carry permit.
So this is a 6-3 decision written by the senior-most justice, Clarence Thomas. What it has done is it has struck down a New York gun law. It was a law that restricted who could carry concealed handguns outside the home. It's a law that stood for more than a century, but the court has now said that that law cannot stand, and that crucially here, the Constitution guarantees the right to carry a gun outside the home. That's something the Supreme Court has not said before.
The reason why that matters is because California's concealed carry permit scheme closely mirrors the licensing scheme that was struck down in New York by the U.S. Supreme Court. And this creates an interesting dilemma. Carrying a concealed firearm under California Penal Code Section 25400 criminalizes situations where somebody carries a concealed firearm or carries a firearm in an improper way within their vehicle. In these situations, the defendant is alleged to have not had the right concealed carry paperwork, usually, in order to store the firearm in this way. In order to prove somebody guilty of unlawfully carrying a concealed firearm, the government has to prove basically that the defendant concealed a firearm on their person or in a vehicle, that they knew about its presence, and that the firearm was substantially concealed. Note, the government has to prove the defendant knew about the firearm's presence. So in situations where perhaps somebody is driving somebody else's car and unbeknownst to them, a firearm is illegally stored somewhere, that defendant may have a righteous argument as the elements of the charges. However, in many cases where someone's dealing with this type of charge, the question is basically, are they carrying a firearm that is unlawfully concealed, either on their person or within their own car? Now note, the government doesn't have to prove that the gun isn't registered to you or something like that. There are situations where the gun is lawfully yours and you're otherwise probably qualified to have the firearm. But if you don't have a concealed carry permit and you carry a gun concealed on your person or in a vehicle, that can be a violation of Penal Code Section 25400, unfortunately. Now, what are the penalties for violating this charge? Penal Code Section 25400 is a wobbler, meaning it could be charged as a misdemeanor or a felony. As a misdemeanor, you could be facing charges of up to 1 year in the county jail and 1 year of probation. As a felony, you could be facing state prison of up to 16 months, 2 years, or 3 years. A grant of probation is still possible in those scenarios, which may or may not be combined with county jail. And as I've said in other videos, county jail can sometimes be served through things that are not actually in jail, through non-custodial alternatives like house arrest or the sheriff's work program. One thing to note is that if you're facing a misdemeanor version of 25400, you can petition the court to have the case diverted under Penal Code Section 1001.95. This charge, like many other charges, is eligible for diversion consideration. And like in other situations, the courts will look at aggravating and mitigating factors, for lack of a better phrase, in your case to see whether they want to give you the chance to earn a dismissal. In some cases, the court may even allow you to get your firearm back after the case is dismissed, assuming the firearm is lawfully yours. Now, there are some scenarios, however, where the charge of Penal Code 25400 does not wobble, and it's what we call a straight felony. Those are situations, I'm not going to go into all of them here, but those are situations where, hypothetically, the defendant is not allowed to ever possess any guns at all because of something in their prior record. Or if they knew or should have known that the gun was stolen, and it was in fact a stolen gun. Or if the defendant is alleged to have been a participant in a criminal street gang. It's troubling often to think that somebody could be facing such serious penalties for what may be seen as just technical violations of firearms law. You could imagine somebody who's an upstanding citizen, has never done anything otherwise unlawful with their weapons, is totally qualified to do it, but they happen to be storing it the wrong way in their car, and suddenly they're facing such severe penalties. We deal with these situations all the time, and if you or a loved one is facing this type of charge, we can definitely help. Note, however, One sort of catch-all to a 25-400 charge is having a concealed carry permit. If you have a firearm concealed on your person, but you have a legal permit to do so, it's not a 2500. Same thing. If you have, if you're driving the car, if you're driving your car and you have the gun loaded and concealed within your car, and you have the relevant permit to do this, not a 2500. Now, I should go back for a second and say that if you don't have the permit, but you keep the gun unloaded and locked in a secure storage container within your car, that's also not a 25-400. That's an exception to the conceal within a vehicle rule. If you're facing some sort of unlawful firearms charge, definitely bring this subject up with your attorney. It is worth a discussion and worth it to see if you have an additional defense in store. That's it for now. For more like this and other videos, feel free to check out our YouTube channel, our website, and our Instagram page. Thanks, and stay safe out there.